Good afternoon. Happy Tuesday. I've had a chance to do a little bit of light reading because, sometimes people want me to be interested in cases and conflicts that I'm not interested in. There's just no way to get me to be interested in. Like the Karen Reed case, could not care less. But the Lane Myers case, fascinating. What's the difference? I don't know. You tell me. Anyway, I was pondering some of the motions that Lane has alleged he intends to bring. I think before I get into that, the first thing I want to say is that I don't believe that Lane Myers had any really critical success in the hearing yesterday. I did re-listen to some of it on my drive to work, and I have to say he did not get much. I mean, he's representing himself now. But he's going to have elbow counsel appointed. He did not get everything he wanted there. He's going to have elbow counsel. And the reason why he's going to have elbow counsel is because the court is not entirely sure that that Lane Myers is going to be able to represent himself. And so there's going to be elbow counsel there who's ready to go take over at the drop of a hat. And, additionally, and that's something the court didn't say. The court obviously said that, if Lane Myers decides anytime he wants counsel, the elbow counsel will be ready to go. And the elbow counsel will be able to assist Lane Myers in going through the discovery and things like that. But the unspoken thing was that if Lane Myers can't represent himself, if the court determines that Lane Myers is incapable of representing himself, then the court is going to have the elbow counsel step in to take over the reins. So that wasn't really a win. It was, it was expected. The issue that he raised orally about, the cases got consolidated. That was anticipated. I mean, you could call that a win for him, but that's both parties agreed to it on the record, and they had already talked about it. So if it was a win for him, it was a win for her too. Him wanting Stiles to give him the disclosures and to talk to him personally was kind of a win. I don't know that it really is going to change anything, but she obviously doesn't want to talk to him. She doesn't like him, and he's difficult. He's a difficult person to deal with, and that doesn't mean he's good. That doesn't mean he's bad. He's a difficult person to deal with. Whatever behavioral issues he has, whatever mental or emotional issues he has, make him a difficult person to deal with, and she probably doesn't want to deal with him. And yeah, judges and lawyers prefer to work with other judges and lawyers because we've seen the results of a non-lawyer. He gets in there and he stirs up a lot of shit, and he makes a 10-minute hearing take 40, and for no real gain. They have to explain things to him like he's a baby. They have to explain to him by calling his girlfriend his wife, it is essentially invoking a privilege, i.e., he's basically saying that she cannot be called to testify against him because she's his wife. If you say, that is my wife, you are saying that she can't be called to testify against you, and yet the state is going to use her to testify against him because she's not his wife. It is a legal issue that he's taking umbrage with on an emotional level, but it's not an emotional thing. She's not attacking him. She's specifying that she can, in fact, call this woman to testify because this woman is not Lane Myers' wife legally. If he wants to call her Sugar Pop Baby Doll, she could be his Sugar Pop Baby Doll. That's not a legal thing. Wife is a legal thing. To be a wife, you are recognized by the state as having all of the duties, privileges, rights, and responsibilities as a wife. You are a married person. It's a legal title, and you shouldn't have to explain that to someone. And if there was another lawyer in the case, it would go unsaid. It would have been Your Honor, my client just refers to her as his wife. They're not legally married. and you move on, right? So yeah, lawyers and judges tend to prefer to work with lawyers and judges because you don't have to explain as many things. There aren't as many breaks. There aren't the outbursts over nothing that Lane Myers does. And also lawyers aren't emotionally invested. Generally speaking, hashtag not all, lawyers aren't emotionally invested in the case. They could look at the facts dispassionately. They could make an assessment of the situation without emotional investment. They can offer counsel to their clients that reflects reality, not wishes, not desires, but reality, so that their client can make an informed decision. I mean, I watched the video, I listened to the hearing on Reluctant Prophet's live stream, and the people in there are just absurd. They're just absurd. I knew that Parvin was a bad actor. Rawr. Like, you're not smart enough or educated enough or knowledgeable enough or skilled enough or experienced enough to know shit about fuck when it comes to criminal actions in the state of Arizona, or what Parvin was doing or why he was doing it. I would bet you dollars. If I was facing a criminal action in Arizona, I would hire Parvin to represent me. He was doing a damn fine job. I have no qualms with what he was doing. And even if Parvin didn't like me, and not a lot of people do, so that wouldn't bother me, but even if he didn't like me, I know that Parvin would fight for me, because he was fighting. He was doing a damn fine job fighting for Myers. He's setting up opportunities for valid appeals. Maybe they're not going to get one, but at least he has the option now. At least he can appeal on some issues. Parvin knew what he was doing. He was setting the record. You know, he was doing all the things. Procedurally, he was going down the list in a very good workmanlike manner. He wasn't leaving anything on the table. I digress. Oh yeah, and the judge doesn't give a shit about this case. Like he is not concerned about this case. He's not concerned about Lane Myers. That hearing was a Monday for him. It was a Monday afternoon. It was another day at the office. You know how you feel walking into the office or walking into your place of employment on Lane Myers supporters probably don't, but for most people, you know, I mean, you go in there, it's nothing new, nothing unusual, just another day at the office. That was another day at the office for that judge. People are like, oh, he stumbled over words. He was lost for words twice. I don't know how people can listen to. Well, I mean, I know. I guess they have no idea what the fuck's going on. But I have a feeling that judge was looking at a computer, and that judge was reading something while he was talking, and his brain wasn't able to go down two roads at one time where he could read and talk at the same time, and that was the cause for him stopping. He doesn't, like, nothing that he was talking about when he stopped even was important on a grand scheme. But people are like, oh, you stumbled over words, oh, he's scared about Lane. No, he doesn't give a shit about Lane. That dude has judicial immunity. There's nothing Lane can do to him. I mean, worst case scenario is that Lane gets him recused, and then instead of having 301 cases, he's down to 300 cases he has to be judge over. Oh, but wait, they'll just add more. I mean, this is not special. I know Lane Myers supporters are heavily invested in this, emotionally speaking, and damn, that shouldn't be legal, whatever that is. So I know they're emotionally invested in this, but this is a nothing burger case. Like, no one was killed, no one was, SA'd or anything like that. I mean, it's just, this is not very interesting. I mean, if it wasn't for Lane, this would be not very interesting. I'll admit it. Lane is interesting, so it's going to be interesting. But the case itself, I mean, it's a harassment case. Who really cares? Who really cares? The judge doesn't. The prosecutor doesn't really. I mean, she's gonna get him. She's gonna do something to get him time. Anyway, so I didn't really see a lot of wins in that particular thing, but he did. There's two motions that I don't practice law in Arizona, so all this with a grain of salt. One motion is a Rule 12.9 motion, where essentially he would get to bring a motion to the judge to say, hey, there was an issue with the grand jury where somehow one of my substantive rights was violated based on the way the prosecutor handled the grand jury. And that doesn't, I personally don't know what exactly he thinks he's going to accomplish, because if he actually prevails on that motion, then it's going to go back to the grand jury. And this is such a simple case. The grand jury gets to see the videos, or at least the excerpts of the videos that are important. He might be complaining they didn't watch the entire videos to get context. They don't need it. So they'll watch the excerpts of the videos where he allegedly harassed her. They'll listen to the various voicemails and emails. They'll read the emails, and the detective might testify, and the victim might testify. They'll probably get presented with, in order for it to be felony aggravated assault, they'll probably get presented with the civil harassment restraining order to show that there was in fact a valid civil harassment restraining order in place at the time the new alleged acts of harassment happened. But it's so simple. Like I don't even know what his issue is. So I guess we'll see when he files the motion. But I don't really think that any of his substantive rights were violated. It's such a simple issue, and he's done such a good job of incriminating himself that I don't know how it would change anything. Because again, if he wins, it just goes back to the grand jury. They present the same documents again, and the same testimony again, and they come back. The grand jury is going to come back with a probable cause determination. You have to remember that a judge found proof evident or presumption great that he had committed felonies and misdemeanors while he was out on probation, bail. While he was out on bail. Sorry, it took me a while to get there. And according to Parvin, who seems to be a good attorney, who seems to know what he's doing, that's a higher standard, that's a higher burden of proof than probable cause, which is all that the grand jury would have to come back with, the finding of probable cause. A crime was probably committed, and you are the one who probably committed the crime. So it's a very low burden of proof, and a court has already found a higher burden of proof. So I just don't like. This is churning the mud, basically. You're not accomplishing anything. You're just spinning your tires. But he'll spin his tires, and he'll have fun doing it. The other motion that's interesting, and I think actually does show some promise for him for getting a result, not necessarily anything that's going to change anything, but getting a result, is the Rule 10.1 motion that he is threatening to file to challenge the judge, basically saying that the judge is biased. Now, what I did my reading on today, my light reading, was on Rule 10.1, and Rule 10.1, you have to show a bias that is not a bias that was generated based on your actions in the hearing. And just because the judge gets annoyed, angry, mad, irritated, short-tempered, or whatever with you, is not a sufficient showing. There has to be, if it's not some outside bias, like for example, if he could show that the judge dated the victim, or if the judge was in a romantic relationship with the victim's husband, or if he went over to the house for dinner on Saturday nights, or if they played poker on the weekends, or whatever. If there was if he could show some relationship, some personal relationship between the judge and the alleged victim and or her family, then there is a possibility of showing the bias, the outside bias. Inside bias, it's a very hard standard to show, and you have to show basically that the court is just flat out going to ignore everything that you say and do, and is going to grant everything the other side says or does, regardless of the merits. It's a very difficult thing to show. The presumption is there is no bias in the judge, and the judge is the one who hears the motion. So, good luck. Now, that being said, when you have to file it within 10 days of the alleged thing that shows bias, of learning the alleged thing that shows bias, right? So, first of all, he might have some time issues related to it. And second, the judge hasn't done anything that I'm aware of. So, good luck to him. But, that being said, the judge also has 300 other cases on his plate, and probably isn't very invested in this Lane Myers case. And I have seen before, I have no experience with this judge, and I have no experience in Arizona courts, but I have seen before where judges will they'll just recuse themselves, even if you didn't comply with procedure, even if you didn't have good grounds for it, simply because why bother? It's going to go up on appeal. It's just a waste. Just here you go. Much like when the judge was just giving me addresses. Oh, that was another win. The prosecutor had to give him addresses, not for the victim or for the victim's husband. No, not those. So that's a loss. Those are the addresses he actually wanted. They had to give him the address for the police department and for his wife, which obviously he knows those. So, that was not a win. That was a loss. But as entirely expected, I would not have expected them to give up the victim's address or the victim's husband's address, because why would they? So, yeah. And I also think it's going to be very interesting, him doing the witness interviews, because at the first sign of trouble, she's going to shut that shit down, the Stiles, and she's going to go to the judge. He's not going to get to, I know what he wants to do. He wants to use the witness interviews to further harass the alleged victim. He's not going to get to do that. He's just not. So, and the judge isn't going to allow it. And, the judge is going to take the victim very seriously if she says that she felt harassed by it. And I'm surprised, I am surprised that he would even get to interview the victim. That California, we've got, what is that? There is a law, it's named after someone, basically the victim can refuse to be deposed or interviewed by the victimizer, the alleged victimizer. I forget what they call it. But yeah, California has it, and I think other states have it too. So, but if Arizona lets him do it, then great. But yeah, the 10.1 motion, the judge might be just F it, I don't really care. You want to recuse me, fine. How someone else is going to treat you exactly the same way. And that's another thing, these people, again, Lane Myers supporters just aren't smart. And, it's sad, and I don't intend to reach them. They come and comment in my comment section, but I want to advise all of Lane Myers supporters that I'm not talking to you. None of my videos are addressed to you. I have a rule, and that rule is I will never try to show someone who's retarded that they're retarded. Because you're just not gonna you're not gonna convince a retard that they're retarded, right? It doesn't happen. You're not gonna convince a Lane Myers supporter that Lane Myers is retarded, because that would make them retarded. They're invested. I'm talking to the people who are either undecided or who are not Lane Myers supporters, right? But one of the very fallacious arguments that they often make. I got bit by mosquitoes so good last night that I am just itchy as heck. But one of the arguments they love to trot out is win ratios, winning streaks. Lane's winning streaks, and so he has a very mixed bag. Like, first of all, he has a very mixed bag. He lost the civil harassment restraining order. He lost the was it Michigan or Wisconsin or whatever federal lawsuit. So he's lost two. The two Tucson City, whatever, the trespassing one, and the one where he booed, those were dismissed by the prosecutor. There was no result on the merits. The prosecutor can refile them. You can call that a win. I would call it a win, but you have to remember that he also has losses. Now, and also apparently at some point in time he was incarcerated, and that's where he got paralegal training. So there's also another loss in there somewhere. But the important thing to remember, that let's just arguendo say that none of those count, and that only the two Tucson City cases, the misdemeanors, the trespassing misdemeanor and the booing misdemeanor, whatever. Let's just say that those are the only ones that count. He gets 100% success rate, right? Past performance is not an indicator of future success. So even if he'd won two, that doesn't mean he's going to win any of these upcoming ones. The fact patterns are different. The rules are different. The procedural rules are different. The charges are different. The victims are different. Alleged victims are different. The witnesses are different. Like on the trespassing one, if my understanding, I mean, haven't looked into it, but I've had so many people comment in my comment section that apparently I needed to know the full story, and that on this trespassing one, the cop that issued the trespassing citation or arrested him for trespassing or whatever, he got him. Lane Myers got him fired, and now he's like a deputy in Texas or something. Well, believe it or not, without having that cop there to come and testify at trial, that's going to be a real challenge to get a conviction. If the cop that arrested you isn't there to testify that he saw you and blah, 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 and all the circumstances that surrounded the arrest, that's a problem. That's a problem that the prosecutor might be like, you know what, I can't proceed with this. I'm just going to dismiss this one unless I can get that deputy back, right? So I mean, like just because you win doesn't mean that you did anything to win. Like sovereign citizens all the time say, oh, well, I got my ticket dismissed. Well, yeah. Oh, the cop didn't show up. Oh, well, that's why you got the ticket dismissed. Or I've seen videos where like they'll be arguing their soft stuff, and the judge will be like, oh, hey, the cop didn't sign this ticket. It's not valid. And he'll dismiss it on something entirely different than what they were arguing. And they'll be like, it's a win for sovereign citizens everywhere. And you're like, no, it's not. I mean, you won. Great. But you won despite yourself, not because of yourself. And that's kind of Lane's MO. Any win he's going to get is going to be despite himself. Right? One of the comments in my comment section was, John simultaneously accuses Lane of being legally idiotic, but at the same time of having the plan of wallpapering the prosecution with motions to basically incentivize them to offer a plea deal. And no, it's not that. The reason why, like, Lane isn't going into this with the idea, I'm just going to keep filing motion after motion until the prosecution gets tired of me and offers me a plea deal that I like just to make me go away. He's going into this thinking, I'm going to file motion after motion because all of these motions are valid, and I don't understand the First Amendment, so I can't understand why I'm being charged with anything. I can't understand why the judge didn't just throw this out on its face, so the judge must be biased, so I'm going to file these motions because I'm going to win. He's not. But his actions might have the unintended consequence of incentivizing the prosecution to offer a plea. A favorable plea. So anyway, that's my 2 cents. His 10.1 motion, I don't believe has any validity to it. won't have any validity to it unless he can allege some sort of outside contact between the judge, outside personal relationship between the judge and the victim or the victim's husband. And I don't see that happening. That's number one. And the Rule 12.9 motion, even if he does have something, which I don't think he does, all it's going to do is force the prosecutor to resubmit everything to a grand jury, and the grand jury is just going to come back with another indictment. I mean, I understand Lane Meyer's supporters aren't smart enough to understand this, but most people realize that what Lane was doing was harassment. I know they don't, none of them want to admit it, and I know I'm going to get stupid ass comments in the comment section of this video, but he only contacted her once, but she never told him to stop. You know, all this shit that's just complete non sequitur, zero basis in actual Arizona law for what constitutes harassment or not. But anyway, most people can realize that, yeah, it is in fact harassment, and Lane Myers should not be doing that. And as a society, we want to disincentivize this kind of behavior. And the method by which we disincentivize this kind of behavior is we make it illegal, and we put people in jail and or fine them and or send them to prison for doing this kind of behavior. That's the disincentive. And so, yeah, expect it. I'm not saying he's going to get convicted, but the odds of him not getting re-indicted if he does succeed on the 12.9 motion are somewhere in the slim to none range. So, and the odds of him not being convicted are also somewhere in the very slim range. Not the none range, but in the very slim range. Who knows? He could get a jury that is comprised of all Lane Meyer supporters. Theoretically possible. Not probable, but possible. Anyway, that's all I got for you today. It was a long-ass video. Thanks for watching if you made it this long. If you made it this long, I'm going to show you my boobies.